Hi, everyone. My name is Senwung Luk. I'm a partner at OKT, and I'd like to welcome you back to the OKT podcast. We're hoping that our podcast is going to become a regular series. We want to build on the tradition of OKT providing topical, useful, and informed perspectives on Indigenous rights in Canada. Our blog is about a decade old now, and we realize that a lot of folks are getting their information in other ways. We know that lots of folks love podcasts because they can listen to them while driving to meetings or on a plane or while they're commuting or while they're doing the dishes. So wherever you're listening from, welcome. And thank you for downloading our OKT podcast. Today, we bring you a conversation with John Olthuis, one of the founders of OKT. He's going to be having a conversation with Ashley Ash and Miranda Dell'Anna, two associates at OKT, about the thing that everyone's been talking about lately, the United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP. So just before they begin, I'll just note that this podcast was recorded early in January 2024, before the Supreme Court released their decision on the C-92 bill. And when our speakers are referring to the Quebec case, they're referring to the Quebec Superior Court decision in the King versus Montour case. So without further ado, here is Ashley, Miranda, and John.
Thanks so much, Senwung, for that warm introduction. Hi, everyone. I'm Miranda Dell'Anna. I use she and her pronouns, and I'm an associate here at OKT. Before joining the team, I completed my JD with a specialization in Aboriginal and Indigenous law from the Borlaskin Faculty of Law at Lakehead University. I'll turn it over next to Ashley for her introduction.
Hi, everybody. I'm Ashley Ash. I also use she, her pronouns. I'm an associate, a new associate here at OKT. Before joining the team, I completed my JD at the University of Windsor Faculty of Law, where I was a teaching assistant in the mandatory Indigenous Legal Orders course. And before that, I completed a Bachelor of Social Work from Toronto Met University. I'll turn it to John.
I'm John Olthuis, one of the founding partners here at OKT. And when I first started working with Indigenous people back in the early 1970s, George Erasmus, when I was offering to assist the Dene in their struggle against a pipeline, Mackenzie Valley Pipeline, George said to me, look, we've been self-determining for thousands of years. The problem is your people have made, because of your political structures, your colonial approach, have made it very difficult for us to be self-determining. So if you want to help us, you should focus on trying to dismantle the colonial system that makes our lives so difficult. So that's been my mantra for all these years, dismantle, dismantle, dismantle. And I think that very much applies to what should be happening under UNDRIP.
Thank you both for those introductions. And with that, we'll get started. As we know, we're here to talk about the UNDRIP Act and the declaration itself. And I'll give a brief overview of it before we dive into our questions. The United Nations Declaration on the Rights of Indigenous People is an international instrument that was adopted by the UN in 2007. 143 countries voted in favor of UNDRIP and 4 voted against. Canada was one of the 4 that voted against, but later became a full supporter without qualification of it in 2016. In June 2021, Canada passed an act respecting the United Nations Declaration on the Rights of Indigenous Peoples into law. The act is meant to affirm the declaration as a universal international human rights instrument that can help interpret and apply Canadian law. So the act itself does not incorporate UNDRIP into Canadian law, and as a result, UNDRIP is non-binding and does not attract the presumption of conformity, which means that legislation is presumed to conform with international law and to Canada's international obligations.
So, just a note here, the principles of international law can be incorporated into domestic law. And when they are, the principles can be enforced by courts like any other provision of domestic law. And there are usually three ways in which international law principles can be incorporated into domestic law. In the case of UNDRIP in Canada, the Act provides a framework for the Government of Canada's implementation of the Declaration. And the Act stipulates that the Government of Canada will consult and cooperate with Indigenous people to do three central things. The first being that it will take all measures necessary to ensure that the laws of Canada are consistent with the UN Declaration. Second being that the government will produce and implement an action plan to achieve the Declaration's objectives. And third, that it will develop annual reports on progress that will be given to Parliament. So that's just kind of an overview of UNDRIP for those who don't breathe and live UNDRIP every day. John, how have you been connected to the Declaration? And do you see any connections with your tremendous work with the Innu Nation and their struggle for self-determination?
Yes, thanks for that question. Yeah. So I do see a very strong connection because in the early 1980s, I was asked to come and meet with Greg Panashaway, the president of the Innu Nation. And Innu, by the way, are First Nations people, not to be confused with Inuit, who also are in Labrador. So anyway, he meets me at the airport. He shakes my hand. He looks at his fingers and he says, "Every time I meet a white man, I count my fingers afterwards." So that was my beginning with the Innu. And one of the issues we were working with was the fact that there was low-level flying in over Labrador offered by Canada to NATO nations in Europe. And this was devastating for the Inuit people on the land because these jets were streaming at 100 feet at supersonic speeds. And the startle effect was devastating. So Innu started to say, well, doesn't the International Human Rights Act protect us? And some of these UN acts, don't they protect us? And this was at about the same time that George Manuel, who was a really amazing Indigenous leader from BC, started saying maybe we need a new declaration. And that was in 1977. His work and there were a lot of connections with him and other Indigenous folks across the country, led then to the United Nations setting up this working group in 1982, and finally doing the UNDRIP in 2007. And we really hope that UNDRIP would provide, would motivate Canada to actually go beyond what they were doing, which was to rely on what the courts have said, that look, Canada is sovereign, and so reconciliation in Section 35 means reconciling to the sovereignty of the Crown. So we'll talk to you, but we run the show, and Innu have been at the modern treaty table for 30 years, and we hope now finally that with the adoption of UNDRIP, that it would be adopted without qualification and would actually mean something. We have not seen that at the modern treaty table in terms of getting Innu jurisdictions, self-government jurisdictions. So, and we were really looking forward to the action plan, hoping that that would involve Indigenous consent to lawmaking and some revoking of laws and so on. So yeah, I have a long history. Learned a lot from Indigenous people. Continued to learn from the Innu over the years. They went many times to Europe. We talked to governments who were conducting low-level flying, and they were dismissive, saying, "Well, Canada controls, what happens on the land and so on." So yeah, we still live with hope that UNDRIP can be turned around to become a real instrument of harmonization of laws. So that's a bit of a long answer, but that's I've been at this a long time, so there you go.
No, it's a good long answer. Sorry, did I miss this? But does the low level flights still do they still occur right now?
They don't do much anymore because they do a lot of virtual training now. But recently, European countries have come back, and Canada keeps offering this because this base in Goose Bay, which established after World War II, is still there, and they're trying to keep it going. So now they're once again inviting Europeans and there's some new reasons why they want young pilots to fly at 100 feet. So we're dealing with that again, that Canada is saying we want to do this. And we're trying to say you can't do it without Innu consent. And they're saying, yeah, we'll talk to you. So the issue remains the same. We'll talk to you, but we'll make the decision, and this could lead to a whole new round of Innu protests, because the first round of Innu protests ended up with about over 200 charges and many, many court cases. We got some good decisions based on a color of right argument that convinced the court that this was in fact Innu land. So yeah, this could be it is on the horizon again, and we hope we can, hope that they can put a stop to this before the contracts are actually signed.
So the next kind of topic we kind of wanted to delve into was looking at comparing UNDRIP and Section 35 right now. So to give a bit of a background to Section 35, Canada's constitution is comprised of the Constitution Act of 1867 and the Constitution Act of 1982. And it also includes Canada's Charter of Rights and Freedoms. The Constitution itself sets out the principles of democratic government in Canada. And of relevance to our discussion today, in Section 35 of the Constitution, it recognizes and affirms the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada. So when we're looking at UNDRIP, we recall that when the 2016 government endorsed UNDRIP, they did so without qualification. The Minister of Indigenous and Northern Affairs at the time was Carolyn Bennett, who said that by adopting and implementing the declaration, we are excited that we are breathing life into Section 35 and recognizing it now as a full box of rights for Indigenous people in Canada. And so I want to draw our listeners' attention to that use of full box of rights, because what we've heard in contrast is Section 35 be described as an empty box. So I'm wondering, John, if you could speak to that empty box kind of analogy a bit.
Yeah, it's a very, very important issue. You may recall, and a lot of folks don't, but in 1969, Canada decided they were going to complete this process of, phases of genocide and assimilation by doing away with the Indian Act. And this aroused Indigenous folks, and I started working with them around this time, particularly Harold Cardinal, who led this response from Alberta. And so there was a real saying, yeah, we hate the Indian Act, but you're not going to just dump us without recognizing our rights. So it was amazing, between 1969 and 1982 there was this resurgence. And then in 1982 I was part of that legal team working with the Indigenous leaders to get Section 35 in the Constitution, and there's a whole, lots of good stories around that. And then there were the 4 constitutional conferences after that, which I was also a part of, that was supposed to be talking about, well, what does this Section 35 mean? So the Indigenous groups, all of them, the Inuit, Métis, and the First Nations, all came forward and said, this is a full box. And what we have to do now is start unpacking the box. We know it's a full box, but if you want to start unpacking it, we'll do that. And all of the governments came, and then Pierre Trudeau was prime minister for the first constitutional conferences, and Brian Mulroney for the last few. There were many different, premiers involved in this, but they were all saying, no, that this is a it means nothing until we say it means something. So this was a huge disappointment, and then of course the First Nations started going to the courts and saying, well, we can't get a negotiated agreement with Canada and the provinces on this, so the courts will help us out. And then the courts of course came with these decisions about that Section 35 means that these pre-existing societies, they call them, not nations, had to reconcile to the sovereignty of the Crown. And one of those very sort of telling statements was made by the Chief Justice at the time in a case called Gladstone. And this is what he said: since Aboriginal societies exist within and are a part of a broader social, political, and economic community over which the Crown is sovereign, some limitations on their rights are justifiable. And then these words: to pursue objectives of compelling and substantial importance to the community as a whole. So colonialism writ large, and that interpretation of Section 35 then confirmed and rather than looking at this as a low bar, saying, well, the courts have said that, but the honor of the Crown requires us to go beyond that and to actually reconcile with Indigenous people, which means a level playing field, and in terms of UNDRIP, it means consent. It means a lot of different things. So that 40 years have passed, and Canada is still implementing Section 9124 laws, rather than saying, no, we have to pull back our jurisdiction. We have to create the room for Indigenous laws to be passed by different Indigenous groups across the country based on their Section 35 rights, and then we have to harmonize. And we kept saying, look, you've harmonized your respective federal and provincial rights since 1867, just based on this list of rights in the Constitution. No, 1,000 pages of contractual agreement. So let's move to including Indigenous peoples in that harmonization. They said, no. And we were hoping that UNDRIP, even how slow Canada was to adopt it, would actually mean that it's adopted without qualifications. But Canada is still I think the implementation, unless it's radically changed, will simply be based on this statement by the Chief Justice Lemaire at the time that, oh no, there's compelling colonial reasons why we can't let Indigenous people run their own affairs. So, long answer again, but a long history.
I want to pick up on, you said harmonization. So I'm wondering if there are any parallels that you can see with the Indigenous approach to Section 35, which calls for the harmonization of the lawmaking authority of the three levels of government, and UNDRIP's provisions.
Unfortunately, I don't. Unless you have a process where these laws involve consent of First Nations, um, I think we're going to see a continuation of the long history of Indigenous folks trying to put something on the table, trying to get their implement their rights in Canada, saying, yeah, we heard you, and no, we're not going to do that. So I think that the whole process really has to like the UNDRIP action plan has to be modified very substantially, and I think the modification has to require and again there's two roles to be played in this. One is by Indigenous nations themselves who are doing a marvelous job. The rest has to be done by Canada's side, and that includes those of us like myself who are non-Indigenous, saying, look, we have to revamp this action plan, and those things happen with plans, and that action plan has to say what we're going to do is look at the laws that are 9124 laws that should be revoked, and we're going to do that with Indigenous consent. In other words, Indigenous consent is necessary, and then we're going to have a process in which each of the involved groups of First Nations, because there are these treaty nations, there's modern treaty groups, actually get to start passing their own laws, and then we're going to see how those three different lawmaking powers, because as you know, UNDRIP does not apply to the provinces, Canada's UNDRIP Act, so the provinces have to be involved because they control lands and resources. So I think that has to be the process, revoking 9124, acknowledging Indigenous rights to make their own laws, doing this harmonization process, and then as many of these, like RCAP, the Royal Commission on Indigenous Peoples, the Truth and Reconciliation Commission, the Penner Report, which was an earlier report after Section 35 came into the Constitution, saying this means a fundamental change. All of those have recommended that this harmonization process happen, and that there has to be involved in this has to be a return of land, and not just jurisdiction but land. And 80% of the land in Canada now is so-called crown land. And so no one is asking that private landowners, should be involved in this because they took good title, even though Canada didn't have good title or provinces to give it to them. But there's this whole issue that there has to be a return of land so that Indigenous folks can actually generate their own income. And there's a lot of steps to this, but so in terms of UNDRIP itself, I think it would be, if Canada continues with this process, another 10 years are going to be wasted in which colonial laws will continue to oppress Indigenous people. And the social well-being stats are that the welfare of Indigenous people continues to decline. So that's very, very troublesome that we now have a process which follows the colonial pattern of we'll talk to you, but we'll make the decision. And it does not involve the provinces who control lands and resources. So I think there's many issues, and one of the big ones is that judicial interpretation of Section 35 and the fact that Canada refuses to take on its responsibility, its honor of the crown, to say that, yeah, that might be what the courts say, but the treaties are made with us, and there's the honor of the crown involved. So we're going to rise above that low bar, and we're going to do this at a level playing field with Indigenous peoples. Again, a long answer, but there's a long history here of this colonial attitude, which is embedded in this 97 pages of action plan, or I think it's close to 97, and all based on, yeah, we'll talk to Indigenous people, but we'll make the decision.
Long answers are needed when there's so many intersecting factors. You had briefly started talking about the action plan, so I wanted to pick up on that and give a little bit of an introduction, again, to situate everything. So the UNDRIP Act has many clauses on cooperation and consultation. And for example, Section 6, subsection 1 says that the minister, in consultation and cooperation with Indigenous peoples and with other federal ministers, prepare and implement an action plan to achieve the objectives of the declaration. The Act requires the development of this action plan to implement the declaration within 2 years of its adoption. And at the time we're recording this podcast, both phases of the consultation phase and processes have run, and the action plan has been released. There are many priorities outlined in them, and I wanted to just draw on one example really quick. So one of the priorities is the Inuit priorities list includes the Government of Canada will take the following actions in consultation and cooperation with the Inuit. The Crown will respect and support the right of Inuit to exercise their right to self-determination, including co-developing Inuit-specific approaches for implementation of the right to self-determination, including through negotiated agreements, new policies, and legislative mechanisms. And there's also a shared list of priorities. And one of those examples includes where a statute requires periodic review. The responsible departments will conduct that review in a manner that ensures consistency with the UN Declaration and meets applicable consultation and cooperation requirements in the UN Declaration Act. John, given your history of working as a member of the Assembly of First Nations legal team that worked on the national Aboriginal leaders, that worked with the national Aboriginal leaders to negotiate the inclusion of Section 35 into Canada's repatriated constitution, how do you see consultation and cooperation requirements operating without a requirement for consent as well?
Yeah, that's the key issue, and I think that I've spoken about that already quite a bit. I think that without the consent provision and without this focus on harmonization and recognition of, and this was why the Charlottetown Accord, which I worked on as well with the First Nations, and that was very interesting because all of the provinces and the federal government agreed to this amendment that clarified that Section 35 included the inherent right of self-government. And that would have been and of course, that was part of a whole package that included like Senate reform and so on. And the problem with Charlottetown in the national referendum was that if you didn't like one section, like you didn't like the Senate reform section, you voted against the whole package. And so it came very close to being passed, but I think it was only about 49% said yes, and that was a huge loss because it was the first time you got this consensus of Canada and all of the provinces, because the Constitution requires 7 provinces with 50%. So that was achieved. So that would have been the beginning of this harmonization. And unfortunately, I think, like what you quoted from the act, it's all very nice, except that Canada says, we'll consult and cooperate with you, but we'll make the final decision. And that's been what has plagued the implementation of Section 35 right from the beginning. And I don't see that there's anything in this implement action plan. And I note that many First Nation groups in the initial consultation process about what should be in the plan said a plan has to include our consent. And certainly Innu Nation that I worked with on their submission, and other clients have done the same thing. And again, that was completely ignored. And there's quotes in the plan, partial quotes in some instances from First Nations who are saying good things about the plan, but what's left out is that so many said it can't work without our consent, because that's been the whole way things have gone since 1982. And look, it, and the Royal Commission, and I want to just the Royal Commission looked at this whole thing too, and I want to just read, and it's an important quote, because the courts have more recently in this Quebec case quoted this. The Royal Commission said, "The road to reconciliation also includes a large, liberal, and generous application of the concepts underlying Section 35 of Canada's Constitution, so that Aboriginal rights are implemented in a way that facilitates Aboriginal people's collective and individual aspirations. The reconciliation vision that lies behind Section 35 should not be seen as a means to subjugate Aboriginal peoples to an absolutely sovereign crown, but as a means to establish the kind of relationship that should have flourished since Confederation." And then it says, "So long as this vision of reconciliation in Section 35 is not being implemented with sufficient strength and vigor, Canadian law will continue to be regarded as deeply adverse to realizing truth and reconciliation for many First Nations, Inuit, and Métis people." And this has been, there are 700 recommendations from the Penner Report, RCAP, TRC, and Missing and Murdered Indigenous Women and Girls, who have all said the same thing. And yet this action plan flies in the face of all of these recommendations. So despite some of the nice words, if you take them on their own without placing them in the context of, oh, by the way, we'll talk about this, but Canada will make the final decision. It means that this is going to continue this subjugation, and I don't. Carolyn Bennett said nice words, but I don't think there's any real intent by Canada to actually implement UNDRIP, and how they've structured the action plan, in my view, just affirms that. So it's extremely disappointing in my view.
So there's a couple things, and I want to get into judicial interpretation of UNDRIP at some point. But I don't want to lose this important pattern, I think, that you're speaking to when we think about these reports, and when we've noticed, or we can point to all the different times that Indigenous folks have come together, shared their stories, shared their lived experiences, and written these reports, given recommendations, very, very clear recommendations to the governments, doing the work for them almost. And then we see this pattern of nothing really coming out of that. And, I just think about the TRC, as one standing out in my mind. And, it's been 8 years, and I think, what is it? I think 81 calls still remain unfulfilled.
Yeah.
So when you think about it in the grand scheme of things, like, for the layperson, 8 years, oh, that's not that many years. But when you put that on top of like over 150 years of colonial violence, well, then it becomes, a sting, I think, more than a sting. And, personally, I don't know if a lot of people at this firm or in public really know this, but, I've done a lot of consultation with the governments in Ontario because I have a lot of lived experience growing up in the residential system here. And so for my own marginalized community, I saw this continued pattern of, let's ask people what they need. Okay, let's ask what's going on. Let's ask how are your rights being violated, and then the government will convene, will write a nice report, and then that will get shelved. And then that happens every 5 years. And so I'm just wondering how we get out of this pattern of that, like how can we move on from this pattern of asking folks, consulting folks, and going what seems like nowhere with that, and I don't even know if there's an answer, but it's like my own reflection.
Well, it's an extremely important issue, and Indigenous people are more than doing their part. I mean, it's yeah, it's heartbreaking. For all these years, there's been this oppression and genocide, assimilation, and yet Indigenous people are strong. Their traditions that have been underground are so. That's why daily I repeat dismantle, dismantle, dismantle. What George Erasmus said to me some 40 years ago. You're the problem. And most Canadians, because of the spin doctors in Ottawa and the provinces, think that reconciliation is happening. And it's most of what Canada calls reconciliation is kind of what the courts have basically said. Yeah, you're going to have to, residential schools, you're going to have to pay back. So it's for some of the horrendous things that they've done to Indigenous people that they're now having to pay for. But there's no movement to say, and yes, we're going to implement Section 35. So I'm constantly amazed at people. And so in our neighborhood, we set up a little library, sidewalk library, and we keep filling it with Indigenous books, fiction, marvelous authors, Indigenous authors, and so Thomas King and the whole works, and about political books. And we find that every week we replenish the supply, and they keep disappearing, and they don't come back because we know people are, and so people in their neighborhood are starting to, you meet them on the sidewalk, dog walking or so, and they're starting to say, yeah, we thought things were getting a little better, but so it's up to non-Indigenous Canadians to really start pushing back at government. And for a long time, churches were involved in this. Churches have backed off because so many people in the pews, work for oil companies and so on, and say, "Oh, and it's completely false that if Indigenous people get the land back, they'll veto everything, because there have been 600 impact benefit agreements across the country. So all Indigenous people are saying is, just like Canada and provinces, you have your ways of deciding what priorities there are for projects. Our governments will do the same thing. So and the 600 impact and benefit agreement show that, you know, if there's benefits to Indigenous people and impacts can be modified. So all of that, you know, information has to start so it is up to those of us who are not Indigenous, and that's why I suppose I'm 83 and I still want to work at this dismantling, and I'm so happy to still be at this firm where there's Indigenous lawyers, you know, doing their thing, but we also have to be working on this dismantling of this system that the courts have and hopefully that will happen. But and there's a lot of people who, young people particularly, who've come to understand about colonialism and have to move then to just push back a little more and say no. This business of having a UNDRIP action plan in which we once again say, yeah, we'll talk to you, but we'll decide, is just completely against what the UN Declaration has said and against what all of these commissions have said and against a basic sense of law and justice. So, yeah, we just have to keep working at it, but and keep trying to educate non-Indigenous Canadians that no, this what the spin doctors in Ottawa are telling you just ain't the case. Sorry about that, but it's not.
So I don't want to lose this point about the courts and judicial interpretation. And I think so far we've seen the courts be really hesitant to opine on UNDRIP at all. And we've seen sort of a number of cases arise, like for instance in BC, which has their own declaration on the Rights of Indigenous Peoples Act. But we recently have the Quebec Superior Court decision, which I believe you were referring to shortly before, which tries, amongst a lot of other things, to address some of the flaws in the jurisprudence so far, and in doing so touches on UNDRIP. And the court really importantly concluded that UNDRIP should be given the same weight as as a binding international instrument in the constitutional interpretation of Section 35. And that decision's on appeal right now. But I guess I'm sort of wondering your thoughts on how you see the courts addressing UNDRIP and why there's this hesitation, and is it stemming out of a lack of understanding? Are we not training judges on this topic? Where is this hesitancy coming, to engage with UNDRIP at all?
Yeah, that's an extremely good question, and I think the interpretation of Section 35 led, of course, Canada initially to say, well, yeah, we'll adopt it, but it has to be consistent with our Constitution. And by that, they've meant with what the courts have said Section 35 means. So the recent decision, I think you're referring to the Quebec Superior Court decision, that was indeed a wonderful kind of reflection on what UNDRIP should mean and lead to a reinterpretation of Section 35. And amazing thing, I think, in that, like John Burroughs is mentioned 17 times in that decision, which is, and the court said the endorsement of UNDRIP without qualification and the adoption of the UNDRIP Act is more than, an UNDRIP Act are more than additional instruments in the Aboriginal law landscape. And then what the court affirmed the following words of Burroughs. UNDRIP's embrace by the Canadian government fundamentally changes the character of the debate surrounding Indigenous law and governments. Vanderpeet and Powagwan should be overturned as they continue to tear the fabric of constitutional reconciliation as it relates to Indigenous people. So I think that's, I mean, as you've said, will that survive the Supreme Court? I hope so. I mean, I've never read such a judgment. 400 pages of such careful analysis, and basically saying, you know, the interpretation of Section 35, this colonial interpretation, we have to drop that. And that doesn't mean that the Canadian government can't start doing this without the court saying so, because by the time this appeal, you know, another, you know, half a dozen years will have been lost. But it is encouraging, and it's due to so many. Well, these 700 recommendations and people like Burroughs who continue to write about this, academics. The courts are starting to pick this up now, so that is very, very, very hopeful. It'd be interesting to see when it gets to the Supreme Court what all these interveners are going to, provincial interveners in Canada and so are going to say about this, because it will speak to where we want to go as a nation, and are we truly interested in, like, we're one of the few countries that are settler colonial countries, like Australia, New Zealand, United States, and Canada, who've actually driven out and exterminated Indigenous people to take their land and resources. It's not like some countries who come in and then take resources and so and then leave. This was exterminating the people. So, yeah, it's changed a great deal. When I went to law school, there wasn't even you know, a course on Indigenous rights, because it was assumed that Indigenous people, because of the policies, will disappear. So there's a lot of reasons for hope, but I think non-Indigenous Canadians have to start looking more carefully at what reconciliation means and saying, no, this action plan does not implement UNDRIP, and it does not implement what we should be doing to reconcile with Indigenous people. I often say that in our personal lives, you know, if you have a dispute with somebody and somebody says, yeah, we'll settle this, you reconcile to what I say and things will get settled. We know the difference between reconciliation with another based on mutuality and reconciliation to the wishes of another. I mean, the whole women's movement and children's rights movements and so have all been based upon that this kind of subjection to the wishes of another, to the patriarchy, is just, you know, has to go. But politically, in terms of Indigenous people, we're still doing that. So we have to level that playing field and commit to reconciliation with Indigenous people. And I repeat again, it's mainly up to the non-Indigenous community to, and it's hard to do because people think, well, if Indigenous people have agreed to this, and I say, no, they haven't agreed to it. Many of them said, we will not agree to an action plan that doesn't give us consent. But this court case is amazing. I read page after page and could only say yes, yes, yes. Let's hope it survives the appeals.
That's a really good reminder for those of us who are non-Indigenous to be aware of as we're moving, forward and seeing the action plan be released and all of these new reports. It's a really good reminder for us to always keep in mind. We have some questions for the audience to think of as a closing.
Including those questions.
What
you can do to help dismantle.
Exactly. That's the number one question. And then we have some follow-ups to think about. So what does consultation with Indigenous people look like in a good way and in a way that is truly rooted in reconciliation? And a second or third question, is there a concern for procedural violence when you ask Indigenous peoples for their input for these large declarations and reports, only for them to have no teeth in our colonial courts and colonial system? Can we do things in a better way?
Yes, excellent question. So I hope we get some positive answers through some action and renewed interest in saying, let's pay attention to these issues and let's tell our government what we think of what they're doing.
Maybe as a final point, John, not to keep asking you questions, but well, that's the purpose of what we're doing here. But do you think we're at a point where we can still be hopeful, or do you think there's a pessimism around UNDRIP? Can we be hopeful for something?
I think we can be. I think there's, as we've talked about, a lot of reasons for hope, and the main reasons for hope is that Indigenous people continue to self-determine. And despite the narrow space that we want to put them in, they're pushing at the boundaries. And I think pessimism would. I think there's more false optimism than pessimism. The false optimism is, aren't we doing much better than we used to? And that's mainly because of, what the spin doctors out of Ottawa and the provinces are telling us, that we're doing all these wonderful things. And then you have something like the Yellowhead Institute report card on TRC recommendations, and you see that not a single systemic recommendation has been adopted. They picked up a few, sort of like repainting the front room kind of one, but none of the recommendations about tearing down walls and so on. So yeah, I think there's a lot of reason for hope, and that I think the younger generation is of non-Indigenous people as well, are getting better informed, and here at OKT, I mean, we have so many like you who are young lawyers, and that's amazing to me. And so yeah, I think there's a lot of reason for hope, but based on what Indigenous people themselves are doing in terms of their self-determination. That's the foundation for the hope that they're not going to give up. So we're going to have to start mending our ways.
I just like to end on a hopeful note, so I just wanted to add that in. But I think just for both of us, thank you so much, John, for your incredible insight and thoughtfulness and just vast knowledge on this topic. And I feel like I've learned so much from you already, and I feel so grateful to be able to continue to learn from you while you're here. So thank you for this.
Thank you for the very thoughtful questions and comments. So look forward to spending more time working and work with you on how to also moving UNDRIP to a better place.
Thank you, John, Miranda, and Ashley, for a very engaging discussion. And thank you to our listeners for listening. Stay tuned because we have an exciting series lined up for 2024.